this video, we're going to be covering constitutional law as part of our highly tested issues guide for the MEE. So let's get started. The first thing I want to discuss is how constitutional law is tested. Constitutional law is now fairly regularly tested on the MEE. In fact, it's specifically tested every year to a year and a half. So it's definitely something that should be on your radar when prepping and practicing. Something else to keep in mind is that constitutional law is usually tested alone as a standalone subject. This means that most of the time when examinees get a question that's testing constitutional law issues, the whole question is only testing constitutional law. However, for the first time in 2019, the National Conference of Bar Examiners tested constitutional law with another subject, and that was civil procedure. Then in 2020, it crossed con law over with corporations. So just to recap, constitutional law is regularly tested on the MEE and usually alone, although it has been crossed over a few times. I want to point out while we're discussing things like frequency on this subject itself, the trend or the frequency of these topics being tested. The issues within constitutional law can be divided into two categories: governmental powers and individual rights. Historically, the issues being regularly tested were individual rights, but the examiners have shifted to now testing things like governmental powers. Thus, they've kind of flip-flopped. And this is a really nice reminder that when it comes to prepping for the MEE and constitutional law specifically, you shouldn't skip reviewing any issue. All are fair game. So now that you hopefully have a better understanding of the frequency in which you can expect this subject to be tested, let's help you maximize your chances of success by talking about those highly tested issues within this subject. So the first thing that I want to discuss is the Commerce Clause and the Dormant Commerce Clause. This tends to be a trickier area where a lot of students can memorize the rules, but they really struggle with the application. So let's break this down. Remember that the commerce power is something that Congress has, and it's a very broad power. The law states that Congress can regulate the channels and the instrumentalities of interstate commerce, persons and things in interstate commerce, and anything that has a substantial effect on interstate commerce. So as you can tell, and as I previously mentioned, this is a pretty broad power that Congress has. The other thing to keep in mind regarding the commerce power generally is that Congress cannot force or commandeer the states to do something. So if Congress wants to get the states to do something or to take some sort of specific action, then Congress needs to either regulate them directly through its commerce power, which again we've learned is very broad, or it can regulate the states indirectly through its taxing and spending power. Now, turning to the Dormant Commerce Clause. Remember that the Commerce Clause was for the federal government, or in other words, Congress. The Dormant Commerce Clause is referring to a situation where a state government is attempting to regulate interstate commerce in the event that Congress or the federal government has not created some sort of regulation themselves. So whenever you see a state attempting to regulate interstate commerce, you should automatically know that this is a Dormant Commerce Clause issue. You should memorize the tests that we apply to situations in which the Dormant Commerce Clause is applicable. When a state passes a discriminatory law, meaning that law favors an in-state industry or a producer over out-of-state, then the law will usually be struck down as unconstitutional. For example, if a state imposes a high tax on out-of-state goods and low taxes on in-state goods, the test that we apply to these discriminatory laws is strict scrutiny. And this is because we do not want states to be protectionists. When you see that a state has passed a law regulating interstate commerce and the law is neutral, meaning it is treating in-state and out-of-state industries and producers alike, so it's non-discriminatory on its face, the test we apply to determine the constitutionality of these laws is a benefit burden analysis. Pursuant to this test, we examine and weigh the benefit that the state is deriving from the law and the burden that it's causing on interstate commerce. If the benefit outweighs the burden, then the law is constitutional and it will likely be upheld. It's more likely that the neutral laws are constitutional, however, it is not automatic. You should also be aware of the exceptions to the Dormant Commerce Clause. The exception that's commonly tested is when the state is acting as a market participant. This is when a state is not trying to act as a regulator, but instead is trying to engage in the market like anyone else would, usually buying or selling products. For example, a state may purchase vehicles from its residents at a high rate and not pay non residents the same rate for their vehicles. When a state is acting as a market participant, then the tests that we just discussed do not apply. Lastly, to give you some insight about how they have tested this topic recently, the examiners have provided a law with different parts. The examinee's job was to evaluate the constitutionality of the law. And usually the law they provided had different clauses or parts, and each would need to be independently evaluated using the different tests and exceptions previously discussed. Turning to another highly tested issue is the Equal Protection Clause. When it comes to Equal Protection Clause being tested on an essay, usually it's tested in the context of things like age and gender. That doesn't mean that they can't test it another way. That's just how they've tested it in the past. So if you're trying to maximize your chances of success with this very highly tested issue, you should memorize the 3 different standards of review, who has the burden, and when it applies. So let's turn to those different standards of review. With strict scrutiny, the burden is on the government to prove that the law is narrowly tailored or necessary to achieve a compelling governmental interest. Strict scrutiny applies to fundamental rights, racial or ethnic discrimination, or alienage. We do not apply strict scrutiny in all cases of alienage, as there are some exceptions. Turning to intermediate scrutiny. The burden is on the government to prove the law is substantially related to an important government interest. This applies to classifications of gender and illegitimacy. Lastly, with a rational basis, the plaintiff or the complainer bears the burden of proof. Rational basis applies to everything else that intermediate scrutiny and strict scrutiny does not apply to. For example, poverty, wealth, age, mental capacity, and education. An essay tip for when the Equal Protection Clause is tested is that it's usually helpful to outline those 3 different standards of review that we just discussed and when you apply each, and then you can move on to your discussion of which one is applicable and why, and then of course your analysis. This shows the grader you understand the issue. Additionally, this is something that is regularly found in the examiner's analysis when they test this issue. So knowing this, you can come up with a canned answer and you can memorize that approach. This will help you feel very confident that you have something to write down immediately when you see this type of issue being tested. Further, the other great thing about familiarizing yourself with those highly tested issues is the fact that it's going to help boost your MBE score. As it relates to the Equal Protection Clause, we know that this is a very highly tested issue on the MBE. So spending some time memorizing this topic will help you on multiple portions of the bar exam. Finally, the next highly tested issue that I want to briefly touch upon is free speech. Free speech is hard for a lot of people, and the reason it's challenging is because there's a lot of little rules to memorize. Given this, there are a few things that I want to remind you of. Don't skimp on this portion of your review. You should listen to your lecture, engage a tutor or a study group to clarify those things that you don't know, and put in the time to memorize. Now, diving into some specific free speech issues, first remember that in order to have a potential First Amendment issue, you need government action. This means there must be a government regulation of private speech. To put a few other things on your radar, you should memorize and be able to tell the difference between content-based restrictions and content-neutral restrictions. If it's a content-based restriction, it seeks to forbid communication about certain ideas or content. For example, prohibiting political speech in a park is a content-based restriction because it prohibits ideas about specific content or politics. whereas a content-neutral restriction does not seek to forbid the content of the speech and instead usually restricts the time, the place, and the manner of the speech. For example, prohibiting protests between the hours of 9 p.m. and 7 a.m. is a content-neutral restriction, as it's only regulating when speech can take place. When it comes to time, place, and manner restrictions, be sure to memorize the different tests that we apply in different forums. The law is different when it comes to regulating speech in public forums versus private. A public forum is a place traditionally associated with expressive conduct, like streets, sidewalks, and parks. Designated public forums are places that the government chooses to open. We treat public forums and designated public forums alike. The test that we apply when we see a speech restriction here is that it must be content neutral as to the subject and the viewpoint. The statute must be narrowly tailored to an important government interest, and it must leave open alternative channels of communication. A non-public forum, on the other hand, is a place that is not historically associated with the free exchange of ideas. For example, a military base, or a government workplace, or an airport. When you see a speech regulation here, the test that we apply is that the regulation must be viewpoint neutral and reasonably related to a legitimate government interest. So this regulation can be content-based. The topic of free speech is dense, and there is a lot to memorize, but it's important that you do so because it is heavily tested. My next tip for you is to memorize the important constitutional amendments and clauses. This will help you build some credibility with the grader, and you can simultaneously build some of your own confidence. So to do this, it's helpful to be aware of which amendment goes with which topic. So for instance, we talked about the commerce power and how heavily tested of an issue this is on the MEE. So remember that the Commerce Clause comes or falls under the Commerce Clause. Remember that the Equal Protection Clause is found under the 14th Amendment. We know that this is a heavily tested issue. As for free speech, you should be able to connect the dot that this is a First Amendment issue. Lastly, as to the topic of eminent domain, which is when the government takes land from a private person for public use, and they must pay just compensation, you should be able to connect the dots for the grader that these restrictions come from the Fifth Amendment, and it's applied to the individual states through the 14th Amendment. It is really great if you can memorize those rules, and then they can serve as a brief introduction in your rule paragraph. This will immediately tell the grader that you know exactly what you're talking about, and it's going to make you feel more confident. Because when you see issues being tested, you'll automatically have something to respond with. This will help you relax so that you can think clearly to fully answer the question in front of you. Another tip is for you to gain an understanding of those trickier constitutional law issues that are tested. Many people think that con law is simple and straightforward, and they don't have to really put time in to understand some of those trickier issues. And that's unfortunate because what we see happen is that students might know the law and they might have it memorized, but they fall flat when it comes to application. So some areas that should be on your radar, and you should make sure that you understand how to apply the law to the facts. For things like the Dormant Commerce Clause, the 11th Amendment, free speech, and distinguishing between the Equal Protection Clause and substantive due process. For example, you can tell that you have a due process clause issue when the law is limiting everyone's ability to engage in an activity. And you know that you have an Equal Protection Clause issue when the law treats a person or class of persons differently from others. If you're struggling to understand these nuances, you should rewatch your bar exam lectures, or hire a tutor, or work with a study group or a study partner. Maybe even spend some time Googling your questions. Lastly, be sure to practice. It's one thing to know the law and another to see how it's tested on the bar exam. So the best way to be prepared is to practice.